All right, and this is the matter of Mariah Collier. City of Riverview versus Mariah Collier, 23R356211. Good morning, your name, good afternoon, your name, please.
Mariah Collier.
Okay, so I know that we've been through this before. I need you to be very loud directly into the microphone. Okay, so if you need to adjust the microphone, you can do so, and then lean in close and say your name again, please.
Mariah Collier.
Perfect. Okay, so you are here on a review date and a show cause because, well, the review date, well, actually, it's the show cause that you're here for today. So you didn't really have to speak to the prosecuting attorney, but you were ordered to participate in random testing. And the show cause is because you failed, it's alleged you failed to register for that drug testing. So when you please raise your right hand. You solemnly swear from the testimony you're about to give this going to be the truth, the whole truth, and nothing but the truth.
Yes.
I'm sorry?
Yes.
Okay, and so you were in court on May 3rd, correct?
Correct.
And what was ordered by this court on that date?
To attend random drug testing.
Correct. And did you register for random drug testing?
No.
Why did you not register for testing?
The day that we were supposed to, my mom took me and the place. First we went to the wrong place, and then when we got there, the place was closed. And so they've been calling every day, but they haven't scheduled me in.
I'm sorry, what? For drug testing?
Yes.
What do you mean you've been calling every day and they haven't registered you in?
My mom's been calling them every day. Like, the place.
And what's the name of the place?
I'm not sure.
That's your responsibility, ma'am. You're the one that's ordered for drug testing. What is the name of the place that you were set to go to register for drug testing?
I don't remember the name.
Where is it located?
I believe in Taylor somewhere.
Taylor? When you left here, ma'am, you went over to the probation department, did you not?
Yes, we did.
Okay, and you received the information regarding Recover Detroit, correct?
Yes.
And the drug testing information.
Yeah.
So what did you do with the drug testing information?
Oh, my mom had it.
Did you read it?
Yes.
And what did you recall reading?
I don't remember.
Did you contact Recover Detroit?
Yes.
And did you begin that?
Yes.
When did you begin that?
Oh, a few weeks ago, I attended the first group on next Monday.
Okay, if you were to test today, which you will be, what is in your system?
Nothing.
Absolutely nothing.
Yes.
And Mom, can you please come up? Can you please state and spell your first and last names for the record?
Heather Collier, Heather Collier.
Okay, and you are Mariah's mom, correct?
Correct.
And so when you received the testing information, what did you do?
We had a date on there, I believe for the 5th. And so after school, we had went down there, like she said, we accidentally went to the wrong place that was right next door, and it was the doctor's office. And then the testing place was closed.
What time did you go?
Roughly around 4.
Okay.
They had just gotten out of school.
Okay, when you received, and what's the name of the testing facility?
I don't know. I know that it's in Woodhaven.
Yes, on Van Horn, DNA.
Yes.
And so when you received all the information from probation, did you read it all?
Yes.
So then you're aware then that DNA testing is open a certain number of hours in the morning and in the evening.
No, I did not realize that. I mean, I read it, but I wear glasses and even then I don't see real well. And somehow I missed that part.
Did Mariah read it?
I don't know, honestly.
Well, she's the one that's supposed to be testing, so she should be the one reading it.
I just know that she knew the date, I knew the date, and then we had went down there. And even like after I picked up my husband, because that's what I do, I pick all 3 kids up from 3 different schools, and then we go pick him up from work, wait for him to get out of work. And then we go home. So when we actually got home, I was explaining to him what happened. And he was like, well, I don't know, I'll call her probation officer tomorrow or whatever. And I said, okay. And then when I had talked to one of my oldest sons, he was looking at it and he said, no, Mom, look, this is what you got to do. This is how it works. And so we've been calling every day to see if her color pops up, and it hasn't yet.
But how do you, I can guarantee you her color has popped up in the last month.
I've listened to it every day with her, and it has not.
They also don't have her registered. So you can be calling, but she's not registered. So what I'm going to do is I'm going to adjourn this.
So is that what she had to register on that first day?
Yes.
Otherwise they won't call her color or?
Correct.
Okay, I did not know this.
So you need to make sure you're there today registering. So stop at probation to make sure you get the steps to make sure you're registering and that they know you're coming to register today and you're going to test today.
Okay.
And then I'm going to adjourn the show cause. Okay? 3 weeks. June 28th at 11 a.m. All right. And then we'll see you back on the 28th, okay?
Okay, thank you.
All right, thank you. Stop over at probation, please, okay?
Okay.
All right.
Okay, this is case 2022-3245 CB, Wakarusa Heavy Equipment versus Oliver and Company, JMC Contracting, Saber 2 Holdings. It is Wednesday, June 7th, 2023 at 1:42 p.m. Attorney Courtney Fisk for plaintiff, John Frazier for defendant 3, Saber 2 Holdings, and JMC Contracting, Attorney Ronald Ryan.
Okay. Good afternoon to all of you.
Hello.
Good afternoon, Your Honor.
Good afternoon. Court will note that this matter is before the court on the plaintiff's motion for summary disposition pursuant to Michigan Court Rule 2.116, parens C, parens 9 and 10 in this matter. I guess I'll ask, I have not received anything from Mr. Ryan or Mr. Frazier, or did you file an answer, a brief, anything in that nature? I don't have anything.
No, Your Honor.
Okay.
Your Honor, no, I took plaintiff's motion specifically focused on count 1 of the complaint, which is exclusively brought against Oliver and Company.
Okay, that's fine. I just didn't have any of that paperwork. I thought I wanted to make sure that we hadn't missed it or anything of that nature.
Yep, understood.
Okay. Ms. Frisk, I've obviously reviewed your motion in depth. And is there anything else that you'd like to add in this particular matter?
Given that the court has reviewed the motion in brief and depth, I don't really have very much to add. I just wanted to briefly note that Oliver and Company has not filed a response to this motion. As far as I know, I have not received anything. And at this time, Oliver and Company is still not represented by counsel. But just relying on the brief and motion, we would ask that our motion be granted.
Okay. Well, let me ask you this. I do have one question in this matter because I had some inconsistencies. In this particular matter, you've alleged that the lease began on 12/10/2021 through the call-off date of June 10, 2022. But I note on page 2 of your brief, at the bottom of the page, you list the call-off date as June 8, 2022, just a matter of 2 days, but and then I asked that raises some issues as it relates to your damages in this particular matter, because I'm not able to square the claim for the damages with those particular dates. And I mean, because you had basically charging and saying there were 4 months, or in page 2 of your brief, you have the 4-month rental period. The total is just over $27,000. Then you have some additional 7 days, which brings it up to just $28,863.02. But if that was the rental period from December through June, that's not 4 months and 7 days. I don't understand what the different dates are.
If I may touch on that.
And you are who, sir?
My name is Adam Liddick. My wife is Elise Liddick. She is the owner of the company. We do not have an attorney.
Okay.
Cannot.
That's fine. I'm staying with Ms. Fisk right now, and then you'll have a chance to speak.
Understood.
So how do I square those, Ms. Fisk?
I'm looking at it right now, Your Honor. I'm trying to square that with what I have with what you just said. So.
I don't want to interrupt, but I was going to perhaps help with that.
Okay, go ahead.
So, Your Honor, I'm not certain as to those dates, but the goal here is for Wakarusa to be paid back, and that's what I've been working on for a while. And so I'm not particularly worried about parsing a couple of days, and however that works. The intention is for Wakarusa to not be disadvantaged in any way moving forward. So at the risk of having Ms. Fisk articulate all those things at a later date, and with the impending judgment today, I would just ask that we not even worry about those days, and we just get an extension, because I believe in several conversations with both Timothy Johnson, both today and in the past 3 weeks, and Mr. Martin, that we have Mr. Martin being the owner of Wakarusa, that we have willing parties to reach a resolution here. And I thought we were already there 3 weeks ago. I think that there's Mr. Johnson, and I don't want to speak on behalf of him, but just in terms of our conversations, and Mr. Ryan can probably touch on that, because I know that him and Tim spoke today, but we're close. And I just ask that we can get to that point. We already have a scheduled mediation. It's been rescheduled twice, and I know that there was no motivation on behalf of the gentleman from Texas to settle. But my conversation direct with Mr. Tim Martin was that we come up with a payment and payment plan, which would have been 5 payments, and we make them direct to him, and that when the payment is made in full, that it would be something without prejudice or something like that. I'm not certain, but
just clarify, if you could, sir, with me, as you stated that on behalf of Oliver and Company LLC. Obviously, your wife, you said, is the resident agent. She's also, is she the managing partner of that, or?
I mean, we both. This is a very small business. It's not.
I guess I'm just trying to discern what your involvement is.
My wife had no dealings with any.
Okay, but regardless of that, I'm just trying to determine your legal basis. I've let you speak, but if you're not a member of that LLC, then you have no reason to, again, appear at this hearing to render any sort of argument. That's what I'm trying to discern.
Hi, sir. This is Elise.
Okay.
So the reason why I've had him in speaking in the previous hearings, even though I'm the owner, he is the only one who's had conversations with everything. So I'm happy to sit in the meeting. I was having him just basically speak on my behalf.
Well, he
we wanted an attorney, Your Honor.
He doesn't have legal authority to speak on your behalf, ma'am. That's the problem.
Okay, that's fine. I can be here. We just we didn't have the money to do an attorney.
I understand.
Well,
then you need to be here because he can't speak on your behalf. So I'm sorry, it may be awkward, but it's just understandable. He can't do that.
Understandable.
Okay. Yep.
Okay. Ms. Fisk, are you aware of anything going on as it relates to settlement or resolution in this matter or not?
No, Your Honor. I spoke with Mr. Liddick earlier this week and then spoke with my client. And to my knowledge, Mr. Liddick did contact my client about a few months ago, I believe.
A few months ago.
You can't interrupt, Elise. I'm sorry.
Oh, go ahead, Ms. Fisk.
I'm not sure what the exact date was, but my client informed me that Mr. Liddick did talk to him, and my client informed him that he would need to speak with me as his attorney. I'm not sure what conversations he's had with other individuals. With Tim Johnson is represented by Mr. Ryan here. He mentioned that he spoke with Mr. Johnson, but I can't speak to that. As far as we are concerned, we have not participated in any settlement discussions. As far as the amount of the invoices are concerned, I'm not sure why, given that he would have been charged more money with the time frame being from December to, what was it, July 8th?
June 10th.
June 10th. If it was a monthly fee of $5,400 for each of those months, that would have been 6 months and then the additional 7 days. So it would have actually been more. So I can't really attest to why it's less. That's just what the client had charged was less than essentially what they were entitled to.
They always have a right to do that, I guess.
Yeah. And again, as I indicated in our brief, and as you know, Your Honor, summary disposition is appropriate even when the damages are the only thing remaining in dispute. So even if that had been an issue where potentially he was charged too much, I could see a dispute on damages, but here it seems as though he was charged too little. And in fact, on that last proration for that final few days that the equipment was in his possession, my client did actually charge him less than what he was entitled to charge.
Okay. Well, we turn to Mr. Ryan. Mr. Ryan, what's your position in this regard?
I didn't file a brief. I've got nothing to add, Your Honor. If there are discussions between the Liddicks and my client, Tim Johnson, I'm not aware of them. I suspect they have talked, but I don't have personal knowledge of that. So I'm not here to dispel any conversations or add to them. I've had a brief conversation with Mr. Johnson prior to the hearing, but we didn't talk substance at all.
Okay. Mr. Frazier, any response on behalf of your client?
No position here, Your Honor.
Okay. Ms. Liddick, I'll open up to you now at this point. You had something to say earlier.
Yeah, my husband, Mr. Liddick, has had several conversations with Courtney as of even yesterday. He's also has communication on his phone that shows he has been in talks with Tim. The fact that he's not communicating with his attorney, I don't know what to speak with that. My understanding was that we were going to try to use mediation. That got pushed back until July. We would still like to utilize that. We've already arranged that to be done. And we've had conversations with these other parties that there can be a resolution outside of this. I mean, I wish my husband could speak because he's the one who's had these conversations. I mean, I guess
it doesn't matter.
Yeah, I mean, they're owed the money. We're not disputing that. There's a whole bunch of other things that go along with that, but I'm not sure.
She doesn't know any of it. I'm sorry, Your Honor, for chiming in. She doesn't know any of it. So
Okay, well, that's fine. That's it's up to you.
I mean,
Okay,
she can read all my notes if that's okay, and if I'm not open to speak.
No, I'm not. I gave you an opportunity, sir, but you're not involved, and I'm not going to allow you to speak.
Understood.
Okay.
I mean, at the end of the day, we are a very small company, and if we had the funds to hire an attorney, we'd have had the funds to pay this a long time ago and get it taken care of. It's going to take us a really long time to pay on this. If they're not willing to work with us on that, I'm not sure where you're going to place our family in the near future.
Okay.
We're still owed money for the work.
We're still owed almost $100,000 from all the work. Okay. You don't know this. We don't have the money to hire an attorney to gather those funds, which we would in turn then be able to pay Wakarusa.
Okay.
So that's where we're at. You know, again, I can't state this enough. It is a small company. Me and my husband, we were not paid in full. We were lied to. Even though there was a document stating we were paid in full, it was a partial lien release. That was not correct. Yeah.
Okay. Ma'am, based on what you've said, you said that they're owed the money and you're not disputing it. Is that accurate? You're not disputing the amount of money and that Wakarusa Heavy Equipment LLC is owed the money on the contract in this case?
Yeah, absolutely owed.
They're owed the money.
They never did one thing wrong.
They never did anything wrong. They allowed us to use the equipment to make improvements on that property. The problem was at the end of the day, we did not get full payment. We were lied to about that full payment. We were to be getting additional funds. We never got those additional funds, in which case we were unable to pay that. We are still in a position that we're unable to pay because of that. And you have this whole job, this whole contract, which is deeper than just this Wakarusa thing, has put my family in a very bad spot. My husband is physically ill. I'm physically ill. We're owed. He's been in and out of the hospital because of this. And it's not just because of Wakarusa. It's because of the entire contract that the other parties were involved and never paid my family in full. So the best we can do, and we've attempted to try to do this, is make payments toward it because that's the best we can do. So
that's okay, please. That's enough.
Anything else, ma'am?
I mean,
we're close to
we want to make it work. I just hope that whatever we can do can make it so that my family's not completely destroyed.
Okay. Well, in this particular matter, you have anything else, Mr. Ryan?
No, Your Honor.
Mr. Frazier?
No, Your Honor.
Okay, thank you. Well, in this case, the matter is very clear based upon statements made today, but also on the fact the court will note that this motion for summary disposition was served upon the parties on April 25, 2023, that there's been no answer, no opposing affidavits or any other documentation in this matter submitted to the court. And as we say today, the parties have acknowledged that they have not responded in this matter to the motion. It does appear that based upon the statements of Ms. Liddick in this matter, that the She acknowledges that the money is owed and that they do not dispute that particular amount, notwithstanding the issue I had originally raised with Ms. Fisk, but they have a right to choose or charge less than would be under the contract if they wish to do so. And in this matter, as I look at it, it does appear that based upon the complaint, when we read through the complaint does, again, provide in this matter that the amount of that a contract was entered into, that in fact the contract was not paid, and that the defendants, Oliver and Company LLC, acknowledges that in their response. And it does appear very clear that there is no legal defense to the claim in this particular matter, notwithstanding the fact that the court would give deference to the non-moving party, which I have in this case, but it's come clear today's date that, again, that they do not have a valid defense to the claim under a C9. Likewise, they have stated today that it appears that there is no genuine issue of material fact as it relates to, again, the claim as a matter of law. And as a result, the court will find that clearly the plaintiff has established a basis under C10 as well. In this matter, there was a contract. The contract was breached, and the plaintiff did suffer the damages as set forth in this matter, notwithstanding the fact that they're different as the court calculates it, but that may be some reason to that, and I'm just not privy to it. As a result, the court will find and grant the motion for summary disposition in favor of the plaintiff and award the damages as set forth in their brief, being $28,863.02. And Ms. Fish, you can submit a order under 7-day rule, and the court will enter that at such time as we receive that, provided there's no objections. Anything else, Ms. Fish?
No, Your Honor. Thank you.
Okay. Mr. Ryan?
No, Your Honor.
Mr. Fraser?
Nothing, Your Honor.
Ms. Liddick?
Can you, because we are not attorneys and not privy to what this exactly means, can you maybe give me a general idea of what that means, please?
What it means is that the plaintiff has prevailed on their case. They've established that you, on behalf of the company, have no legal defense, and that there is no dispute in this case except the matter of damages, which the court has addressed through Ms. Fisk's brief and her calculation.
Okay, so I guess this question is more or less to Ms. Fisk. So regarding the mediation that is no longer taking place. Let
me tell you, you don't have a right to ask a question of Ms. Fisk in this. This was a motion. Okay. You can contact Ms. Fisk later if you wish to do so and engage in any discussion or anything else you'd like to, but it's not appropriate for today's hearing.
Okay, my apologies.
Okay, that's fine. You don't understand. That's understandable. Okay, with that, the court will close the record at 2:04 p.m. And Ms. Fisk, we'll look forward to getting your order for summary disposition.
All right, Leah Fox.
Your Honor, Ms. Fox refused the services of the Public Defender's Office today.
Okay. All right, first one is an older one. On the record, State of Michigan versus Leah Fox, 2201896 SM. Are you Leah Fox? Okay, in this case, it looks like it's an older file for which you have a failure to appear. So this is a domestic violence alleged to have occurred on or about June 3rd, 2022, against a Robert Young. You were scheduled for,
Trying to see here. May 9 for final pretrial and May 23rd for jury trial. Looks like you failed to appear on May 9 for final pretrial. A warrant was issued for your arrest. You must have had some kind of interim bond here. It looks like you had law enforcement contact on May 14 and failed to appear to be arraigned again on May 30th. So hence we are here today on your failure to appear. Ms. Fox, you have the right to have an attorney in this matter. And if you could not afford one, the public defender could be appointed to represent you. You have the right to have a trial that could be by jury. Apparently you were scheduled to have a trial. At that trial, you have the right to see, hear, and question all of the witnesses against you. You have the right to bring witnesses in your own defense, and you could get a subpoena to make them appear. You have the right to testify at your trial if you wanted to, but if you did not want to testify, the prosecutor could not use your silence against you. You have the right to be presumed innocent unless they can prove that you are guilty beyond a reasonable doubt. Now, are you sure that you don't want a public defender to help you with this?
Sure. I didn't even do it. I don't even know who the fuck he is no more.
Yeah, I'm looking. I see the name of the victim was listed originally as Robert Young, but I think his name is Robert Pearl.
Yeah, Robert Young Pearl.
Okay. Well, I mean, if you dispute whether you did it, wouldn't you want to have an attorney to help you present your side of it?
But why am I even still dealing with this? If he first of all hasn't even showed up to press charges against me, and second of all, why the fuck? I already done time for it 4 times already.
So don't swear at me. Okay. So the problem is there's a trial date where he would have to be present and testify. And unfortunately, you keep not getting to the point of forcing him to show up or not show up because you have to show up for your trial. And when you don't show up for a trial, then it doesn't matter whether he showed up.
You guys hear what I go through every fucking day?
You got to show up for things and to resolve them. And if you don't show up, then this is what happens.
It'd be easier if I had a fucking house.
Okay. You need to stop swearing at me.
You spoke from the rain already. I already know you're gonna rain there. I can tell because your face isn't popping off.
So they put this back on for pretrial on June 27th, it looks like. Due to your persistent failures to appear and your refusal to deal with counsel today and you're swearing at me, I'm going to set your bond at $5,000 cash surety with no PR. And all the other conditions will still be on there, including the no contact order for Robert Pearl. I still have to arraign you on an ordinance file as well. I'll do that right now. This ordinance file alleges that, well, let me call it properly. City of Lansing versus Leah Fox 2301538 This alleges on or about May 13, 2023 at 4:48 p.m. that you were at 112 Regent Street near East Michigan Avenue, City of Lansing, Ingham County, and that you were trespassing in a red tag property. That's a misdemeanor violation of city ordinance punishable by up to 90 days in jail and or $500 in fines plus court costs. Do you understand?
I know my judge looks like, and I have to face off. That's not my judge.
Fox, you're almost done.
That's not even the person that's usually sitting next to her. Watch.
I'm the arraigning judge today, so that's who you get today. Your regular judge will be Judge Flores, and you'll see him at your court date, but I'm the arraigning judge today.
I'm not listening to you. They'll talk to you. Can I go back to myself?
Nope, you're going to listen to this.
I don't need to listen to this bitch. She's not a judge.
Okay, defendant's unable to be arraigned on this file today. We won't complete this arraignment. You can just hold her on the other file. Thank you. This one has to have a new K53 go with it because it's an assault case.
Look, it's not even a real thing. What?
Case number 23S00435, that's the People State of Michigan versus Denisha Red.
Your Honor. Secretary on behalf of the people. Good afternoon, Your Honor. May it please clerk Alvin 24501 on behalf of Ms. Red, who stands to my left.
And Ms. Red, your name?
Denisha Red.
All right, and you're here, Ms. Red, for looks like a pre-trial and a malicious destruction of property, over $200, but less than $1,000. So it's a 1-year misdemeanor with up to $2,000 fine, or 3 times the value of any of the property that was allegedly destroyed, whichever is greater. You understand the charge? All right, you certainly have a right to trial by judge or by jury with your lawyer representing you. You understand that? Okay, Mr. Andrews, how would you like to proceed?
Your Honor, we would respectfully ask the court to schedule this for a bench trial. With, still reserving the right to a jury trial.
You have a complaint with me?
Yes, Your Honor.
You want a bench trial? You want to fill out the bench trial waiver form? And ma'am, you understand you have a constitutional right to have a trial by jury, which means you, your lawyer, and the prosecution would all have a right to select jurors for the community, 6 of them. They could listen to whatever evidence is presented. They decide the facts of the case, and they decide if you've been proven guilty beyond a reasonable doubt. And of course, they all have to agree on a verdict. You understand that? So if you're going to waive your right, I would sit as a trier of fact. You can do that in a second. You can listen, and then I'll give you a chance to read that too. That means I would sit as a trier of fact. I listen. I decide what the facts of the case really are, and then I would decide if you've been proven guilty beyond a reasonable doubt by the prosecution. And of course, my verdict would be 1 person alone, as opposed to 6 jurors who would have to agree on the verdict. You understand that difference? And you think you still wish to waive your right to have a jury trial? Anybody force or threaten you? Anybody promise anything to you? You're waiving that right freely and voluntarily after talking to your lawyer. Go ahead and read the form now, and then sign it when you're done. Okay. And you have the prosecutor sign it?
Yeah, I have to fill it out.
Okay. All right. So I'm going to find, if people wish to waive their right to jury too.
Yes, Your Honor.
Okay, then I'm going to find that her waiver is freely and understandably, voluntarily, and knowingly made. Set it for a bench trial.
July 28th at 10:30.
July 28th, 10:30. All right, that's the date. Violence continued. We'll give her a notice to sign, and I will give you back your waiver form once you get it all filled out.
Thank you, Judge.
Okay. Come on back. This is 23S435. SM People of the State of Michigan versus Denisha Red. Now, I'm recalling this case because I understand you want a bench trial without waiving the jury. When I asked the prosecutor, did he have a victim? He said yes. Usually I only do that when we know we don't have one, or there's a large possibility that we don't have one. Do you know for sure you got one?
In terms of their cooperativeness?
Yes.
No, Your Honor, I don't know what we're in.
Your Honor, I believe this will resolve if
in the future. When I ask, do you have one? That's what I mean. Are they gonna come? Are they gonna be here and ready? Okay. You got it, Mr. Andrews. We won't waive. We just set it for bench trial. We won't waive the jury. So if a person comes, she can still have a jury trial if she wants.
Thank you. And I apologize. It's my fault. I should have been more clear.
Okay. Waive the jury. We still got the same date, right?
Yeah.
Yes. Okay. July 20th, 10 a.m. I will tear the form up.
Thank you, Judge. Sorry.
No problem. Okay. Next.